Hey guys, Christian here with Chapter 2 of your Notary Educational Course. Alright, let's go ahead and go over notarial acts and procedures. Chapter 2, Part A. Tools to function as a notary public. Section 1, the notarial journal. A. One active journal. One active journal. A notary public must keep only one active sequential journal at a time containing all notarial acts. Keeping more than one active journal is never allowed. For example, if a notary public performs notarial acts at multiple offices, that notary public cannot use and store a separate notarial journal at each office. Instead, that notary public must use one journal and take that one journal to each office where services are performed. So it's very important to keep only one journal, and this is so that the transactions can go ahead and be in chronological order. All right, Chapter 2B, Securing the Journal. No person except the notary public can have access to the notary public's journal outside of the notary public's presence, including an employer who paid for the notary public's journal. So even if your boss paid for your supplies, he is still not allowed to go through your journal without your presence. The journal must be stored in a locked and secured area that is under the direct and exclusive control of the notary public. For example, a locking file cabinet, a safe or locked office. An office safe or a file cabinet that any other person has access to is not an area under the direct and exclusive control of the notary public. It is unacceptable, for example, to keep the notary journal in a locked desk at home if other family members have access to the contents of the desk. Failure to secure the journal may result in the suspension or revocation of the notary public's commission and civil and criminal penalties. All right, Chapter 2C. Sequential recording of official acts. All official acts performed as a notary public must be recorded in the notary public's active journal at the time the act is performed. The journal entries must be made sequentially by recording each notarial act in order of occurrence one after the other. A notary public is guilty of a misdemeanor if the notary public willfully fails to properly maintain his or her notarial journal. A notary public is guilty of a misdemeanor if the notary public willfully fails to properly maintain his or her notarial journal. So we went ahead and I think that's a typo, but let's go ahead and repeat it, that way it sticks. So it's very important, and one of the reasons that you would be guilty of a misdemeanor is because so much tampering could occur if the journal is not in chronological order, and there's also a lot of sensitive information in the journals, and they must be kept away from other individuals who could, do something bad with that. I'm not saying that the people around you are necessarily bad. However, if it does get in the wrong hands, something with that information could happen. So let's go ahead and move on to D, copying and inspection of journal. Any member of the public may request a photostatic copy of the journal entry representing a transaction. Once again, that's any member of the public may request a photostatic copy of the journal entry representing a transaction. The request must be in writing and must include the name of the parties, the type of document, and the month and year in which the notarial act occurred. The notary public may charge no more than 30 cents per page for a copy request. However, a member of the public is not entitled to obtain a copy of other line items that may be on the same page of the notary public's journal, and care should be taken to ensure that only the requested line item entry is disclosed. So if someone is to request a copy of their line item entry in your journal, be sure to only send them a copy of their information and not anyone else's. Again, there's sensitive information in these journals, so be sure that when you do send a copy over to the individual requesting the copy, be sure that it doesn't include anybody else's information. All right, the notary public must respond within 15 days of receipt of the request with either a plain copy, not certified, of the requested journal entry or an acknowledgement that no such line item exists. A notary public performing notarial duties for an employer must permit the employer or the employer's auditor or agent to inspect and copy journal entries. However, the inspection and copying must be done in the presence of the notary public, and the journal entries being inspected and copied must be directly associated with the business purposes of the employer. The notary public upon request of the employer must provide plain copies, not certified, of all journal entries that are directly associated with the business purposes of the employer. So they can't just request random copies of random transactions within your journal. It has to be associated with the business. Upon receipt of a subpoena ducis tecum or a court order, the notary public must provide the journal for examination and copying while the notary public remains present, and the notary public must certify those copies if requested. E. Surrender, loss, or destruction of journal. The notary public's journal is the exclusive property of the notary public, and it cannot be surrendered to anyone except as required with respect to a peace officer and county clerk as specified below. Even if the notary public's private or public employer has paid all of the costs to obtain the notary public's commission and has paid for all the costs to provide notarial services, the notary public cannot allow their employer to handle the journal outside the notary public's presence and cannot surrender the journal to the employer upon termination of employment. A notary public must surrender their official journal immediately or as soon as possible if the journal is not present to a peace officer acting in his or her official capacity who has reasonable suspicion the journal contains evidence of a criminal offense and who is investigating that criminal offense. If the notarial journal is surrendered to a peace officer, the notary public must obtain a receipt for the journal and must notify the California Secretary of State by certified mail or any other means of physical delivery that provides a receipt within 10 days of that date of surrender. The notification must include the dates covered for the journal entries in the surrendered journal, the notary public's commission number, the expiration date of the notary public's commission, and a copy of the receipt given by the peace officer for the journal. If a notary public's official journal is stolen, lost, misplaced, destroyed, damaged, or otherwise rendered unusable, the notary public must immediately notify the California Secretary of State by certified or registered mail or any other means of physical delivery that provides a receipt, aka FedEx, UPS. The notification must include the dates covered for the journal entries, the notary public's commission number, the expiration date of the notary public's commission, and when applicable, a photocopy of any police report that specifies the theft of the journal. If a notary public surrenders the official journal, or if the notary public's official journal is stolen, lost, misplaced, destroyed, damaged, or otherwise rendered unusable, the notary public must obtain a new journal. If the old journal is returned or found, entries must not be made in the old journal. The notary public must continue to use the new journal. And this right here, the purpose of this is so that the transactions that are recorded in your journal do not get out of chronological order. So if you were to get that old journal back, it's fine. You would have to turn that in or keep it safe because you cannot add any more entries at that point. If a notary public resigns, is disqualified, or is removed from office, the notarial journal and all other notarial records must be delivered to the clerk of the county in which the notary public's current oath is on file within 30 days of the resignation, disqualification, or removal. I'm sorry about that, guys. All right. Additionally, if a notary public's commission expires and the notary public has not obtained reappointment within 30 days after the expiration of the commission, then the notarial journal and other notarial records must be delivered within the next 30 days to the county clerk. Even if a notary public has applied for reappointment, but for whatever reason is not granted a commission within 30 days after expiration of their commission, the notary public must deliver the notarial journal and other notarial records to the county clerk within the next 30 days. Willful failure to deliver the notarial journal and other notarial records to the county clerk within the appropriate time is a misdemeanor, and the notary public is personally liable for damages to any person injured by the non-delivery. Okay, section 2, seal. This is your notary stamp. A notary public must have and use a seal purchased from a vendor or manufacturer authorized by the California Secretary of State. A. Form of seal. The notary public seal must be photographically reproducible, have a serrated or milled edge border, must clearly and legibly contain the state seal, the words notary public, the notary public's name, and the commission expiration date, the county wherein the oath and bond are filed, the commission number assigned to the notary public, and the sequential identification number assigned to the manufacturer or vendor by the California Secretary of State. The seal may be circular, but not over 2 inches in diameter, or it may be rectangular and not more than 1 inch in width by 2 and 1/2 inches in length. I honestly have not seen a circular stamp in recent years. Most people use a rectangular stamp, but as long as you follow these rules, you should be okay. As long as you could, make a photocopy of it, should be all right. There have been issues with like just plain embossers. There's been notaries that just try and use an embosser without any ink on it, so you can't. Those actually don't come out well when you make copies of them. So they really do have to specify that it has to be an ink stamp that is legible when you create a photocopy of it. So best practices tip: because the seal must be photographically reproducible, the rubber stamp seal has become almost universal. However, notaries public may use an embosser seal in addition to the rubber stamp, or may use an embosser seal as the official seal if the embosser seal is inked. So there you go. So you can use the embosser seal without ink, but in addition to that, you have to include the rubber stamp. Now, people usually don't ask for the embosser. Usually it's been older people, usually above the age of 50. Not saying that's old, that's still young. However, they're usually the ones that tend to request the embosser seal, and you can do it. However, you have to let them know that you have to place a rubber stamp next to it because the embosser seal is not inked unless you do have your embosser seal inked, and at which point it is photographically reproducible once it is inked. If it is not inked, it will not come out well in a photocopy. Okay, so chapter 2, obtaining a seal. A notary public can purchase a seal only from a manufacturer or vendor authorized by the California Secretary of State. The California Secretary of State issues certificates of authorization with which a notary public can obtain an official notary public seal. Only the original certificate of authorization and not a copy can be used to purchase a seal. A certificate of authorization to obtain an official seal will be provided by the California Secretary of State with the Notary Public's commission. So when you obtain your commission and the Secretary of State, they've done all their background check. You've done the process pretty much. At that point, you have it completed. They send you a packet, and within the packet, there's a form that is titled, let's see exactly what it's called. It's an authorization form. The exact name of that form is, believe it's authorization to manufacture notary public seals. And when you get that form, it's a blue and white form. At that point, you would have to mail that form in to whoever your vendor is, and the vendor is in the company or manufacturer that will be creating your stamp. So they need that original copy, or that original document, So yeah, so you will be receiving that in the mail, so look out for that. Once you receive it, you have to issue that over to whoever is manufacturing your seal. And it's important that you get it out to them right away, because once you get your supplies, the clock is ticking. You only have a certain amount of days to go and purchase your bond and file your oath and get ready. But usually manufacturers will sell you a packet with your bond and your stamp, so look out for those type of deals. We also have those type of deals on our website. If you go to the resource center, if you didn't already purchase it, you can purchase it there for $149, and we sell you the bond and stamp and journal and ink pad all together for $149. Okay, let's move on. C, securing the seal. The notary public seal must be kept in a locked and secured area under the direct and exclusive control of the notary public. Remember, like the notary journal, no one else except the notary public can have access to the seal. An office safe or file cabinet that is accessible by others, even if it's locked, is not acceptable, nor is a locked desk at home if other family members have access to the contents of the desk. Failure to secure the seal may result in suspension or revocation of the commission and civil and criminal penalties. The notary public seal is the exclusive property of the notary public and must not be surrendered to an employer upon termination of employment, whether or not the employer paid for the seal. The only exception to this rule is when a seal is surrendered in response to a court order and will be discussed later in detail. All right, Chapter 2, D, use of the seal. A notary public must use the seal solely for the purpose of carrying out the duties and responsibilities of a notary public. There is only one situation when the seal is not required. The use of the seal is not required for acknowledgments on California subdivision maps, since the material used for such maps is generally not compatible with ink used on seals. So that's the only reason why you get a pass on that one, because the material used for such maps is generally not compatible with ink used on seals. So that's the only exception. In this one case, the notary public's name, the county of the notary public's principal place of business, and the commission expiration date must be typed or printed. You could also write it in there with a pen below or immediately adjacent to the notary public's signature on the acknowledgement. Many documents that are acknowledged may later be submitted to a county for recording. The county recorder might not accept the document if the notary public seal is illegible. All elements of the seal must be visible. The seal should not be placed over signatures or any printed matter on the document. If the seal impression is not clear, the notary public should affix a new impression and never attempt to fix the old one, even if this requires attaching a separate notarial certificate. So this right here is very important. I think this is one of the key points of this course and I say one of the key points because when you're actually out there on the field, this will come in handy. The first time I ever did a notarization, I placed it. It was like a funky type of stamp. It was really stiff, and I pressed down on it. I'm not sure if there was something under the document. The whole point is that the seal was not legible. And the next day, I get a phone call from an angry escrow officer, and she's like, "Hey, I need you to redo this this document that you notarized." And I said, "Hey, I'm sorry, it was my first time." And she said, "Yeah, I can tell." And so it's a huge deal. And the reason it's a huge deal, of course, to escrow and title companies is because the county recorders will reject it if the seal is not legible. So it cannot be placed over anything else. The seal has to be on its own, away from any other print, anything else. And of course, do not attempt to fix the seal. That's only going to look more suspicious to the county recorders, and it'll give them another reason to reject it. So at that point, you would have to attach a separate notarial certificate if there is no more room on that document to add a new seal that is not, over writing or printing or anything else. All right, so let's go ahead and move on to E, lost or damaged seal, destroying seal. Any notary public whose official seal is lost, misplaced, destroyed, broken, damaged, or is rendered otherwise unworkable must immediately mail or deliver written notice of that to the California Secretary of State. If requested by the notary public, the California Secretary of State will issue a new certificate of authorization for a seal within 5 working days after receipt of the notice, which a notary public may use to obtain a replacement seal. The notary public or his or her representative must destroy or deface the seal upon termination, resignation, or revocation of the notary public's commission or the death of the notary public. And that is very important. If someone happens to find your seal and they do some fraudulent things with it, they're going to be coming to ask you questions, and you want to avoid that. So destroy the seal when you're no longer a notary. All right, Part B. Types of notarial public acts and how to perform the acts. Part B explains the most frequent and important acts in California law that a notary public may perform. Please note, a notary public only can use the notary public seal for purposes described in the California Government Code and can only use the title Notary Public to render notarial services. A notary public must refuse to perform any notarial act that is not described in California law. For example, a notary public is prohibited from using the official seal and title Notary Public either on documents that are not described in California law or without the required notarial wording. Doing either of these prohibited acts may cause the notary public's commission to be revoked or suspended or the application denied. Most notarial acts relate to another person signing or certifying a document. When a notary public performs an act in relation to a document, the document is commonly said to be notarized, not certified. All right, guys, it's notarized. In fact, a notary public only notarizes the signature of the person who signed the document. However, a notary public cannot notarize his or her own signature or a transaction in which the notary public has a direct financial or beneficial interest. Yeah, guys, so now that you're going to become a notary public, you can't just go around notarizing, wills and, things that'll benefit you. You have to be very careful with that. And also even notarizing, it could get tricky in court, but we'll go ahead and we'll dive into that later on when you notarize like family members and whatnot. And always be sure to check in to the extra training videos. We cover topics like this, but definitely you cannot notarize your own signature or any other signatures or documents in which you will gain something from the notarization. So that's a key point right there. And that's a basic point I think that we should have all been able to, assume that would be on here. All right, so Chapter 2, Section 1, the essential basics. So you must examine a document. 1. An incomplete document. A notary public cannot take an acknowledgement on a document that is incomplete. When presented with a document containing a signature to be notarized, the notary public should visually scan the document to determine if the document is complete. Blank spaces and blank lines should be examined to ensure information is not missing. Also, if a notary public has experience with a particular type of document and knows what information should be stated in the document and that information is missing or incomplete, the notary public must refuse to notarize the signature. So yeah, if you become familiar with documents, definitely use that knowledge to your advantage and make sure that the documents are filled out, and this will prevent, a lot of fraud from happening. And especially right now in the internet age, for example, like power of attorney forms, healthcare directive forms. There's a lot of, people just tend to Google these forms, and these forms are always at the top of Google. And, people don't want to look on page 2, page 3 of Google, so they'll just go ahead and download that one. So believe me, I've seen the same power of attorney form used like 50 times by like 20 different people. 50 times, by, 50 different people. And it's it gets so repetitive. You become very familiar with these documents and you begin to recognize them. And I'm like so familiar with power of attorney at this point that, if they have a missing section, I could tell them without, really looking at the document. I don't have to study it. I already recognize what section of the document it is, and tell them what needs to be placed in there. So you do have to make sure that there is no incomplete areas, and this is for the safety of the public and your own safety as well. You don't want to be called into court and be asked questions regarding this transaction that is recorded in your notary journal. So Chapter 2, Number 2, foreign language documents. A notary public can notarize a signature on a document written in a foreign language, whether or not they are familiar with the language. So I'm going to go ahead and repeat that. A notary public can notarize a signature on a document written in a foreign language, whether or not they are familiar with the language, since a notary public's function only relates to the signature and not the contents of the document. So can you imagine, if you're from, if you're from, Latin American country, then, in California, you'll have some luck. You'll definitely meet plenty of Spanish speakers. But let's say, for example, you're from the Middle East, or, you might be from China or Korea, how are you going to find someone that speaks your language, and then again, that is a notary, that is available at the moment that you need them? So that is not an issue. You can notarize documents that are in a foreign language, but let's go ahead and look at the other requirements. However, a notary public must be able to communicate with the customer in order for the signer to swear or affirm the contents of an affidavit or to acknowledge the execution of a document, as well as to enable the notary public to obtain proper identification of the signer and to complete the required journal entries. As an interpreter should not be used because vital information could be lost in the translation. If a notary public is unable to communicate with the customer should be referred to a notary public who speaks the customer's language. So there you go. So, I mean, there's a lot of people, like, let's say, for example, that speak, that are bilingual. They speak more than one language. So if they could speak English and let's say they speak Chinese, Mandarin, and they're like, hey, I understand English, and you just need to ask them, hey, do you understand what you're signing? And they say, yes, I understand what I'm signing. That's all you need to worry about. And you just notarize their signature, make sure it's them signing, and stamp it. You're good to go. But you need to be able to ask them in English, do you understand what you're signing? Or in the native language that they are speaking. And you have to be able to ask them if they understand what they're signing. And if they say yes, then you're good to go. So for me, I've done that plenty of times in Spanish. I've spoken Spanish to plenty of, because there's been transactions that are 100% done in Spanish, and the documents are in English, and they do understand what they're signing. So I am able to notarize that. So the notary public should be able to identify the type of document for entry in the notary public's journal. If unable to identify the type of document, the notary public must make an entry to that effect in the journal. A document in a foreign language. So that's what you would write in there. As in all cases, the notary public should determine if the document is complete and must not notarize the signature if the document appears to be incomplete. So always look out for that. The notarial certificate in a foreign language document or attached to a foreign language document, the acknowledgement, jurat, or proof of execution by a subscribing witness must be written in English. The California law requires these forms to be followed exactly, and they appear in California law in the English language. Please note also, special rules apply to advertising notarial services in a language other than English. These rules will be discussed later. So we'll go ahead and dive into that later, because you could get in a lot of trouble for advertising notary services in a different language, especially in Spanish, as a notario público means something completely different in Spanish. It's like a lawyer, so we don't want to give people that impression that you're a lawyer and give legal advice, because a notary public is not allowed to give legal advice. So as you can see, let's go ahead and go over this again. The notarial certificate in a foreign language document or attached to a foreign language document, the acknowledgement, jurat, or proof of execution by a subscribing witness must be written in English. California law requires these forms to be followed exactly, and they appear in California law in the English language. So what I was going to dive into here is, I've notarized documents that are pretty much all in Spanish. However, even if the document is in Spanish, your section, which is the acknowledgement or the jurat, it has to be in English. It has to be in English. You cannot place your stamp on a document that is not in English. And this is just by law. In order to place your stamp on any document, it has to be accompanied by a specific language. And when I say specific language, I mean the wording, the verbiage, and also the English language. So it cannot be in Spanish, cannot be in Mandarin, it cannot be in anything else. It has to be in English for you to place your stamp on it. So my Spanish speakers will definitely come across some documents that are almost 100% in Spanish, if not 100%. And you have to remember to, bring out the acknowledgement that is in English if they did not provide one. Okay, or the jurat. All right, so B, verify identity of the signer. Examine document. Before performing most notarial acts, the notary public must confirm the identity of the person signing the document. For acknowledgments and jurats, a notary public is required to obtain satisfactory evidence of the signer's identity. 1. Satisfactory evidence. Satisfactory evidence is the absence of any information, evidence, or other circumstances which would lead a reasonable person to believe that the individual is not the individual he or she claims to be, and A. Identification documents meeting certain requirements, or B. The oath of a single credible witness, or C. The oath of two credible witnesses. Since January 1st, 2008, a notary public's personal knowledge of a signer is not sufficient to establish the identity of the signer. So you used to be able to use this. My mom's been a real estate agent for like 25 years, and she was also a notary at some point. So I know at some point this was actually valid, and it's not even, too long ago, just 10 years ago. And you could actually notarize a document on personal knowledge. So if you knew your grandma, or you knew, your friend you've known for years, you would just, hey, I don't need to see your ID. I know who you are. Bam, place the stamp. But it's not allowed anymore. So you always have to see ID, no matter what, even if you know them for, 15 years. There is a way around not seeing an ID, but we're going to go ahead and dive into that later. And I'm sorry, when I say there is a way to not see the ID, I mean the ID of the signer, because you will have to see other people's IDs in this method that we will discuss later. But for now, let's go ahead and go on to identification documents. The identity of the signer can be established by the notary public's reasonable reliance on the presentation of identification documents meeting the requirements of California Civil Code Section 1185B3 or B4. In addition, there must be no information or circumstances leading a notary public to believe a signer is not who the signer claims to be. The types of identification documents listed below may be presented to a notary public to establish identity. These identification documents must be current or have been issued within the previous 5 years. An identification card or driver's license issued by the California Department of Motor Vehicles, or a United States passport, or an inmate identification card issued by the California Department of Corrections and Rehabilitation if the inmate is in custody in California State Prison, or any form of inmate ID issued by a sheriff's department if the inmate is in custody in a local detention facility. So for this, actually, when I do notarizations in a correctional facility, I just tend to look at the wristband. So that's where, in 2018, that is satisfactory evidence. So, and they do state it right here, but I know they made it clear this year in 2018 that a wristband works, but it also states it right here: any form of inmate identification issued by a sheriff's department if the inmate is in custody in a local detention facility. So yeah, don't be alarmed if you ever get a call and they say, hey, I need you to do a notary in a correctional facility. Don't get alarmed and be like, hey, how are they going to access their ID? Oh my God, what do I do? How are we going to do this? You would just go ahead and write down their information on the wristband. Usually it's just a booking number, date of birth, and their full name. But you definitely can complete the notarization with just the wristband. So other California approved identification cards consisting of any one of the following that contain a serial or other identifying number, a photograph of the named person, a description of the named person, and the signature of the named person are also acceptable. These forms of identification must also be current or have been issued within the previous 5 years. A valid consular identification document issued by a consulate from the applicant's country of citizenship, or a valid passport from the applicant's country of citizenship. A driver's license issued by another state or by a Canadian or Mexican public agency authorized to issue a driver's license. So yeah, usually passports work when it's any other country other than Canada and Mexico. If it's Canada and Mexico, you can take a driver's license. So that is great.